sure. Shut up. If you ask me a question, I can't answer while you're talking.
Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair.
Another threat. Wow.
You're probably going to hear more than one. Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn and I'll continue to up the ante. I don't give a shit if you object. Is it clear what I said? I'm in charge. I get to do shit you don't get to do. It's part of the black robe, okay? That's just the way it works. My courtroom, I get to decide how it's run. Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two?
Have you ever had a grilled cheese?
Other issues as well.
You're in contempt of court. Put him in.
All right, guys. Today's clip is Wild Weave. Got yet another sovereign citizen who seriously thinks he can outsmart a judge with a bunch of made-up legal nonsense. But this judge, it's not having any of it. It's no patience, no dramage.com. Logic and straight facts. Watching this guy try to argue fake laws while the judge calmly shuts him down is honestly satisfying. It's like watching a masterclass in how to deal with delusion. What really gets me is how these folks still believe they're somehow above the law. News flash. The court does not care about your fantasy rules. Drop a comment if you think the judge handled it perfectly, or if you think he should have gone even harder. Let's jump in.
You're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to.
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
And if I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has,
he can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on the record?
Yes.
Are you on your oath to the Constitution?
Hold on. Are you picking him up? That's one of the reasons I want you up here, is through the microphone here.
I'll speak loud.
Are you picking him up?
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oath to the Constitution.
You haven't.
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
may
All right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make, and that, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record.
Okay.
So with that being said.
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
So today,
Do you have a jurisdictional argument you want to make?
what I've served notice.
Sir,
on
it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
Yes
multiple
or
arguments.
no?
This guy seriously just cannot keep his mouth shut. The judge makes a solid, reasonable point, and instead of letting it land, the sovereign citizen just keeps going, talking in circles. I honestly don't get it. Why do these people feel the need to argue with every single question? It's not complicated. The judge is simply trying to find out whether this guy missed his court date on purpose or if it was a legit mistake. But no breather than just answer like a normal person. He acts like the law doesn't apply to him. Does he even realize he's making things worse for himself? I can't tell if they're clueless or just think they're the smartest person in the room. Either way, let's get back into it.
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of Michigan?
District courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that
I work under the authority of the state of Michigan.
What is it under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is
and
it?
It's not common law. It's statutory.
Okay, so it's statutory. That is what, civil?
No.
So what is it?
My jurisdiction is both civil.
I can't defend myself unless I have it on the record. Is it
my jurisdiction?
It's only two.
Sure. Shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is
this? Is a criminal case.
Okay, right. So is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record?
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the people of the state of Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
you want to see it?
Affidavit, sworn affidavit?
No, it's not. I don't think it's an affidavit.
Well, okay, so
you said you wanted a sworn complaint
from an injured party.
This guy literally got exactly what he asked for at his last hearing, and now he's walking in like he has no clue what's going on. Judge Martin, who was his original judge, actually went out of his way to set aside the default because this guy filed a motion requesting it. The court gave him exactly what he wanted. Yet here he is, acting all confused about the date, like it's someone else's fault. Sovereign citizens, man, they have zero respect for the court, the legal process, or even the taxpayers footing the bill for this circus. Do they not realize how much time and money they waste dragging things out with their fake legal scripts? What do you guys think? Should judges even bother entertaining this nonsense? Or just start handing out jail time the moment it starts? Let's get back to it.
Who have I injured for the record?
The state of Michigan.
How can I
are bringing the charges?
How can I injure the
state?
Sir,
sit down. Sit down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat. Wow.
You're probably going to hear more than one.
I see.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge. The people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you. So I'm asking you to state your name.
Your witness. Yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name?
No, you still will.
That's fine. Thank you. Witness.
Your Honor, the people call Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is okay. So right here,
This is the probable cause hearing.
It says it's
All right, stop. Right now, the question on the table is you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Need to start taking these guys seriously. I mean, Sheriff. You look back a few seconds into the clip, maybe it wasn't crystal clear whether the judge was speaking directly to him. But come on, that doesn't excuse the nonsense that followed. This guy is all over the place, and honestly, I wish we could see his face while he delivers these ridiculous arguments. Sits giving full clown energy. Even if there was a little confusion, he could have just stayed quiet or asked for clarity. Instead, he doubles down with nonsense that makes zero legal sense. If anyone out there can explain what this guy's trying to say, I'm all ears because I really try to stay grounded in actual law, not sovereign citizen fantasy land. At least the judge finally shut it down this time. Let's jump back in and see if this guy dares to interrupt again.
Under what grounds am I denied not?
Because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objections to the
I
evidence.
object that we are having a preliminary exam when I haven't had a probable cause hearing that I did not.
They're the same thing, Mr.
It's
Michaud.
still on this.
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different date that says a preliminary.
Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two separate?
Have you ever
columns?
had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day and I asked the court to waive his appearance so that he could remain with his family.
Which we
I
did.
understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony. Do you have any questions based on that?
At what point did I waive it? If it's a hearing,
You didn't
right,
waive it.
so
There's nothing to hold.
Do I have a right to have a probable cause conference?
No.
What?
You can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There's no preparing for a probable cause conference. It's a conversation.
It still takes preparation.
You want a PCC? Go out in the hallway, have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC.
Be fair? This guy's argument isn't the worst we've heard from a sovereign citizen. Instead of the usual no jurisdiction or I'm a flesh and blood. Man, nonsense. He's actually claiming that some officers told him it was okay to drive while the one who ticketed him said otherwise. Honestly, that's a step up from the usual sovereign citizen circus. It's almost refreshing to hear a bit of common sense, a little bit. Normally, we're working with 2 brain cells max, but today, I'd say maybe 4 or 5. Still, I think he's playing dumb. Legally, the officer had clear probable cause if you're carrying. You have to disclose your CPL, and yes, you also need a valid driver's license. It's not rocket science. Are you guys buying this story? Personally, I don't believe a word of it. Let's jump back in and see how this plays out.
Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those 2 things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he gets to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to—
He can appeal them.
As you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that the waiver does not preclude him from
not at all
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to their burden, he also maintains the right to continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to—
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
criminal what?
bid bond.
Hold on.
I
What?
requested the bid bond, the performance bond. I have an affidavit.
There
and
is
I
no
did-
bond.
There are bonds. This is
Okay,
you said it's
listen,
criminal.
listen. You can't tell me something and then just disagree with me
Well,
and think
okay.
listen to me, sir. I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe. Okay, that's just the way it works. My courtroom, I get to decide how it's run.
Into your objection, Judge. I don't like your answer. I swear, that's basically what this guy's argument boils down to. Yeah, the law says one thing, but apparently, this super legit book he probably bought off Amazon says he can just do whatever he wants. It probably also told him that all he has to do is represent himself. Yell objection every 5 seconds, and boom, he's untouchable. Like seriously, who needs actual legal knowledge when a self-published fantasy guide tells you everything? You want to hear? These sovereign citizens just crack me up. But to be honest, part of the blame here falls on our education system. Schools really should be teaching basic legal understanding. Unless you go out of your way to watch court videos or study law on your own, most people just don't know the basics. So while these folks are clearly in fantasy land,
There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone
I
here
don't-
has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address. Okay, so
I'm not addressing any of that crap you
Can
got in
you-
front of you.
well, since you say you don't have a bond, can you express that in a via affidavit so I can have
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent affidavit of fee schedules for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice and.
Great.
you haven't-
Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney.
Okay, you
Okay.
said that.
Right, and
Move on.
you haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't
am not
recognize
a
any of that.
United States citizen. I am
Stop.
actually
Hold on.
identified.
Stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does
Can you
mean, hold
prove
on. It does, it should mean something
Can you
because,
prove it? Please prove it.
can I prove
then.
what?
Prove that I am not that I am the artificial person.
I can prove you're Frank
I have
Michaud.
full faith and credit.
I can
I
prove,
have, okay, so.
hold
I
on,
have-
hold on, you've
Are
asked
you-
me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.
And I
You
actually
proved
you
it for
threatened
me.
You threatened me.
But if you're not you, the threat means nothing.
It doesn't mean nothing. But you
Okay?
still threatening me and you're using it under color of law.
Okay, listen,
And plus
listen
you
to
have,
me. Mr.
you
Michaud,
have, you have.
I've
multiple
wasted
officers.
too much time with you. Yes or
Okay.
no?
So,
Sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or
I
no?
object. I will address,
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you in 30 days.
what do you guys think should legal literacy be taught way earlier in life? Let me know, and let's dive back into the chaos. School CHOL handled like a pro-nessly. I think the judge nailed it. Stayed calm, didn't take any nonsense, and made it crystal clear. The law is the law. No matter how many excuses this guy tried to throw out, it's just frustrating watching people waste the court's time and taxpayer money with arguments that have zero legal ground. This guy acted like he was starring in a courtroom drama, pulling out excuse after excuse, while the rest of us are paying for it. And let's talk about those ORV laws real quick. Just because one officer says it's okay and another doesn't mean you get a free pass. That's not how it works. Officers can still write tickets because at the end of the day, the law isn't based on opinion, it's written, and it's enforceable. If you don't have the right license or paperwork, you're still breaking the law, period. All right, that's going to wrap it up. What did you guys think? Was the judge spot on? Did the defendant at least seem more reasonable than your average sovereign citizen? Let me know down in the comments. And if you enjoyed this breakdown, don't forget to like and subscribe. Appreciate the support, and I'll catch you in the next one. Take care.